The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting.
Thank you. Please be seated. Good morning. Welcome to the Supreme Court of Kansas. We look forward to an invigorating discussion with counsel this morning on the issues contained in the briefs. With that, I will ask the Clerk of the Appellate Courts, Ms. Carol Green, to do the honor of calling this morning's docket.
Appeal number 104,236, University of Kansas Hospital Authority versus Board of County Commissioners. Board of Commissioners of the County of Wabaunsee County on petition for review. Wabaunsee County agrees both sides.
Your Honors, appellant appears by Jennifer Martin Smith and Elu Bjorgard Pravasco.
Justices, the Board of Commissioners of Wabaunsee County appear through counsel Norbert Merrick, County Attorney.
Appeal number 106,214, State of Kansas versus Nestus, Stevens County agrees both sides.
Christina Curls of the Appellate Defender Office for Mr. Mastis, present and ready for argument.
Paul Kinsky, Stevens County Attorney on behalf of the State of Kansas.
Appeal number 105,182, State of Kansas versus Simpson on petition for review. Judges and counsel on both sides.
Your Honors, may it please the Court, Deputy County Attorney Michael Serra on behalf of the State. You did.
Sorry. May it please the Court, I'm sorry. John Kurt on behalf of the appellee, James Simpson.
And that concludes the morning docket, Your Honor.
Thank you, Ms. Green. Before we proceed with calling the first case, I notice we have what appears to be at least one group of visitors. We have their adult supervisor stand. Announce who you are.
Chief Justice Lou Mulligan and Professor Chelsea Hayes from the University of Kansas.
Very good. Thank you. Any other groups? Very well. We'll turn to the first case on this morning's docket. I call case number 104236, University of Kansas Hospital Authority v. the Board of Commissioners of the County of Wabaunsee, Kansas.
Good morning. Again, Norbert Merrick, County Attorney of Wabaunsee County. Justice Nuss, if I could break my argument by having 10 minutes on the main and reserving 5 minutes for rebuttal.
5 minutes is granted.
Thank you, sir. This case concerns a situation in Wabaunsee County where a gentleman who was at the courthouse jumped from the 4th floor window and incurred injuries. We're primarily here for 3 particular reasons. 1, concerning custody, its definition. 2, when does it end? And 3, should potentially the statute 1910 control the situation? The primary factor here obviously concerns custody. In this case, the Court of Appeals focused on 3 issues that it deemed created a custodial situation. It spoke of a secured building at the Wabaunsee County Courthouse on the 4th floor. It's in the evening, the building is locked coming in. It's not locked going out. In other words, it's set up to prevent people from coming in there after hours when the business is closed. The other factor listed by the court was essentially the officer's instruction to this gentleman, have a seat. Need to go look at some things, check some paperwork. At the same time, another officer was looking for the personal effects of the gentleman. That's why he had come. He wanted to get the return of his personal effects. The third factor occurred.
Mr. Merrick, he wasn't just sitting in a waiting room, though, was he? It was sort of a secured area?
Justice, I think that depends on your opinion.
Okay.
That area, you do come into the deputy's area past a secured door. To get in there, you have to know the security code. To leave there, you press the red button and walk out.
Oh, okay. The room that he was sitting in at the time he jumped out the window was
is
a
an
room he
inch.
could have left on his own without anyone else helping him.
Correct, but that's a different door. You come into what we call a day area where the officers might do their reports, where the Intoxicalizer 8000 is. There's a little room off that called the fingerprint room, the
Right.
interrogation room, the visitor room, whatever you want to call it. That's where he was set. That's the place that people sit when they're waiting inside that door.
And that room,
In that room, the door was shut also. When he was asked to take a seat, the door was shut. Whether it's secured, again, your opinion. That door is a hollow core door with a bathroom
could he
style.
walk out of it on
Yes,
his
he
own?
could.
He
It
could
was
have
not
walked out
locked.
on his own.
Yes.
Wasn't there
He had
video? of
There is a video, and he
And it
walks up
shows
to
him
the door.
trying, and it opens the opposite direction.
Correct. It appears
Counterclockwise,
that
or-
he turned it
yeah.
one way, which would be a traditional way you would turn it, but the door is reversed so that the little
Right.
button lock is on the outside as opposed to the inside that you would typically find on a little bathroom door. So he does walk up in the
And isn't the
video.
purpose of that, I just want to find out, isn't that purpose of that so that people can't easily walk out of there?
Well,
I mean, what's the purpose of having the door, the lock on the outside essentially, or the little,
yeah, if you were to use it, for instance, if you were having visitation, that room has a little portal, and a prisoner would be put in there, the door locked, and the person visiting, their mother, brother, whatever, would be on the other side, sitting in a chair. It's a temporary situation because, again, the room is used for multiple purposes, but that would be the reason that the little button lock, if you will, is there. Keep in mind, the room doesn't have any bars on it. There's a window, but it doesn't have bars like the rest of the facility.
and the video shows he tried twice to open the door unsuccessfully, the way you would normally open a door.
I think,
Clockwise.
Justice, that you, yes, you could see
And
it.
then before he jumped out of the window.
Correct. Yes. And I think that covered, then the question is, the officer, have a seat. Well, what meaning do you subscribe to that? Clearly,
Well, the meaning I would subscribe, and I know custody is different for different purposes. One of the factors we look at for whether someone is in custody is whether he's free to leave or she is free to leave once they're told to be in a certain vicinity or a certain place. And are you telling me Mr. Contreras could have gotten up and walked out of there and had no one pursuing him to further confine him, to detain him? It seems to me that the whole purpose of putting him in that particular room was to confine him for a certain amount of time until they get information. Wasn't that the whole purpose of putting him in there? I mean, you didn't have him sitting in a waiting room outside, which you could have done. You put him in a room so he would be confined until you got further information.
that's partially correct, but there was nowhere else to put him so that he wouldn't just wander around the courthouse.
So he just wouldn't walk around, or
Right, we wouldn't want-
what's the point then?
We wouldn't want someone to go play with the Intoxilizer 8000, which is just right outside the door there.
There was
What's
no,
the point?
there was no seat there? You mean when someone comes in to that facility, there's just no other place to put someone while they're waiting for someone to maybe get released or whatever happens?
The only other place is outside the door that leads into the day room. That's where people sit during the day when they either have an appointment with the
And so what was
sheriff.
the problem with putting him there? If you don't want to confine him?
Because the courthouse is closed, and if he decided to wander downstairs, he could by bringing him in there. Also, because the deputy, she's the jailer, she's in charge of the jail that night, so she doesn't have time to be going out there. She brings him in there so she can go into another room to look for his personal
But
effects.
didn't the sheriff's officer, Lamb, I think that's his name, say, I want to get more information on this person, I want him in here so I can get that information? I mean, it's...
Yes, he did. He wanted to get more information because he was wondering what was going on here. That isn't much different than, I guess, a Terry stop.
And
which
in
is
a
not
Terry
arrest.
stop, you're just not free to leave during that investigatory short phase, isn't that right?
That's correct.
All right. Okay, go ahead.
Counsel, before you continue, I did want to ask, what is the standard that we use to determine whether he was or was not in custody?
Well, that is a very difficult question. There are a couple answers for that when you look at various opinions of the court. You could start with 22-2202-9, the statutory definition of custody. True, the courts haven't always used it. Two other lines of cases then have provided guidance. There's State v. Lewis, which is mentioned in one of the earlier cases of this area of law, the Butler County case. There you have a person who is involved in a wreck, kills 6 people in a DUI. He's escorted to the hospital by the police. There are 2 or 3 of them present there at all times, and when the hospital is done with them, they arrest him. And he needed to be in custody because if you wanted to admit the blood tests, the court had to find he was in custody, and indeed they did. There's one other line of cases, though, that sort of goes somewhat the other way. That's the Miranda cases. Take State v. Canaan. In that case, in Miranda, keep in mind it's important that they not be in custody if you want to admit the statements. In that case, the gentleman was escorted to the hospital by the police after a police chase. Officer Atwood was assigned to stay with him until released, but he was not restrained at the hospital. He was left alone for significant periods and arrested months later. In that case, they said he wasn't in custody. Most recent illustration of that is State v. Warrior, which Justice Lukert wrote, and there's an 8-factor test that she refers to in discussing custodial situations. So those seem to be some other bodies of law that we can look at to get some idea of custody if we go beyond the statutory definition.
Mr. Merrick, what do you think is the source of the county's obligation to pay these expenses?
Well, this is really a case law developed situation. We start with a basic concept of providing by statute humane care for prisoners. We expand that to the idea that if you're confined, well, gosh, you can't go see a doctor, there's some bars in front of you. That makes sense. Now, how do we step further and further away from that? Where's the cutoff of that level of care? So I think what we have in Kansas right now is this developed line of case law, and the question that the county here is concerned with is there an end to it? Is there some situation where you're not in custody? Because in all the cases that established this area that we've worked our way through from 1977 to 1988, the counties always ended up paying.
Can that case law continue in light of legislation?
Well, I think that's what this court may have to decide. I reference 1910. That statute went through some changes in 2002. Primarily, we think because of the Haskell case concerning reimbursement from the prisoners. But if you read that statute, one might wonder, is the legislature putting down the screws? Because they specifically reference 2202 as their definition. They specifically use the word prisoners and in the county.
That's why I'm questioning, why are we even talking about custody rather than prisoners?
Well, because we have that case law out there, and 1910 hasn't been interpreted in any way. I cited it even at the lower court, but Judge Elder did not address that, and neither did the Court of Appeals. Lastly, I have to tell you that there has been another statutory change. 2 new statutes became effective July 1st, 2006. They also deal with this, and as you may know, the Court of Appeals on September 13th entered a decision interpreting that statute, which would appear to overturn Wesley, a 1985 decision of this case. So those statutes, which would not pertain to this case because of the date.
Do you agree they don't have retroactive application?
I do, and the trial judge said that also.
So we're just looking at 1910.
Right, because it's the only one you could look to for some statutory guidance that had changed between Butler County, 1988, the last case that really touched upon this, and then this enactment in 2002 amending 1910. Now, 1910 had been around for a very long time, but in 2002 it was substantially amended to deal, presumably, one, with reimbursement. In other words, if the county pays for medical expenses, it can later file a civil suit against that prisoner to collect what it paid. So that right was created. But again, if you look at the language of it, it uses specific words and uses the statute in reference to what it's doing.
And your position on 1910 is that it simply doesn't apply. He wasn't a prisoner, and he hadn't been committed to the county jail, which seems to be the...
Yes, but a third factor, Section B specifically references 22-2202. Is that the legislature saying we're going to use that to just tell you what a law enforcement officer is? Or is that also what we're going to use to define custody? Because that statute appears in a clause in the first sentence of B1. So because no court has interpreted that, I will have to rely on the wisdom of this court to see what you think of that particular situation. As I mentioned, we know that the main reason the legislature did it was because of the reimbursement situation, but the language they used doesn't clearly come into that. Now, the other part of that, the other reason they made that change is because of, well, there may have been other cases, but I'll say the McKay case. When I was assistant county counselor in Riley County, we had a gentleman, Mr. McKay, stopped by a Kansas Highway Patrol trooper on the Gary-Riley County line, just inside Riley County. He was arrested, got out of the police car, approached the officer, and the trooper shot him. He was taken to Riley County Hospital, in a hospital in Riley County, Mercy. County got a big bill. He was being arrested on a California warrant, and he was injured by this trooper. So that statute then said, well, if you have an injury caused by a state law enforcement officer, the state will pay. So that was the other thing that 1910's amendment accomplished. It appears I've used up my 10 minutes in answering your questions. Unless you have more, I will return to you with my final 5 at that time.
Any more questions of council? Thank you, counsel.
May it please the court? My name is Jennifer Martin Smith, and I represent the University of Kansas Hospital Authority, the appellants in this case. The central issue before the court this morning, from our perspective, is whether or not Alfredo Contreras Gonzalez was in custody, thereby rendering Wabaunsee County responsible for his medical treatment. As we've discussed, it's long been the law of Kansas that a sheriff has a duty to care for his prisoners, and that has been expanded to fit what we look at as more real-world situations. It's not always so cut and dried that somebody is placed under arrest, put in the county jail, and then they receive an injury.
Do you agree that we have to start with the statute and we stop with the statute, or can we still look at these 1977 and 1980? I think the latest case was 1988. Can we still look at those in light of the 2002 amendments?
I don't think that the 2002 amendment had a significant impact on those prior cases. The point of the 2002 amendment was in response to Haskell versus Sullivan, which said that the counties couldn't seek reimbursement from the prisoners because there was no statutory authority to do so. And so they added the phrase, all costs incurred by the county for medical care and treatment of prisoners shall be paid from the general fund.
How do we divorce the use of the word prisoner under the facts of this case, which all of the other cases, there seemed to be either the person was actually a prisoner at the time of an escape, the person was being arrested, in the process of being arrested for a felony, was under a protective custody under the alcoholism and treatment programs. I mean, those sorts of things. In this case, there's no basis to have held this man in custody the time he came into the jail. So how do we divorce it from the term prisoner?
Because there are different indicia of custody at that point.
No, prisoner.
Right, I'm sorry, from prisoner. At that point, had Captain Lamb actually had the time to go out and finish looking at the ICE detainer before Mr. Contreras jumped, he testified he would have handcuffed the guy and put him back in the jail so that Immigration and Customs Enforcement could come and pick him up. He was in a protective custodial situation like the prisoner, or I'm sorry, like the protective custody alcoholism fellow. And even though that statute says prisoner, it said prisoner in 1977 when we had the Mount Carmel case, and it also still said prisoner in 1981 when we had Dodge City, and again in the Gray County case.
So if we would follow that line, then we have to analyze whether the ICE detainer was like a warrant that he could have just pulled somebody into custody solely based on an ICE detainer?
No, I think we have to look at what the intentions were, and as the court stated in State v. Lewis, whether he was free to leave. And I think when you look at the circumstances surrounding that, Mr. Contreras was not free to leave. He was on a locked floor in a room that he couldn't get out of and was told to wait there while we checked it out. The county can't put him in that sort of protective, isolated state and then suddenly when he jumps out say, oh, well, he was free to go the whole time.
I think there's a difference between the constitutional obligation to provide care and perhaps, what I want to know is what do you think the source is then of the county's obligation to pay the third-party medical provider? Is it just a fairness sort of thing? Is it statutory?
I believe it's a combination.
Tied to the where does that what is the source of that?
It's a combination of the statutory law that says that the sheriff has a duty to care for people that are prisoners in their custody. And then this court's interpretation of what custody means based on those statutes and the fact that KSA 22-2029 doesn't always control in these instances when it doesn't make sense, when you don't have the specific person saying you're under arrest at the time he's laying and bleeding on the ground. Another important factor, I think, is when he went to the jail that evening, the only person on duty was Jailer O'Connor, a woman, and she specifically testified in her deposition that she put him in the fingerprint room because she was alone in the jail that night and she was a woman and she felt that that was a more secure area. As the court questioned earlier, he couldn't just wander out. He couldn't leave the fourth floor. That was the jail floor. Yes, he entered the courthouse of his own accord, but once he took that elevator up to the fourth floor and the jailer met him at the elevator door, she had to key in a special code to get in, and he then was locked into the jail and then put again in this secure room. And the video clearly shows he tried to leave. He tried to open the door, he knocked on the door, and then when nothing happened, he resorted to jumping out the door.
Window.
I'm sorry, yes, window. It's also, I think, imperative to know that when he first arrived that night, the jailer looked down, realized who it was, and said to herself and then testified, well, this guy shouldn't be here. When they knew he was a drug-running felon, he'd been caught with a load of cash, 50 pounds of pot, and they had sent him on with significant instructions to both Shawnee County that he had this detainer, that this guy was a criminal. He wasn't some visitor who happened upon the Wabaunsee County Courthouse one evening. He was somebody that was known to them as a felon. They had specifically faxed and sent copies to Shawnee County and to the district attorney to say, look, this guy is trouble. So when he showed up at Wabaunsee County, Jailer O'Connor testified she thought maybe he'd actually escaped from prison. And so the first thing she did was call her supervisor and say, hey, this guy showed up at our door. What do I do with him? And her captain, Captain Lamb, told her, hold him there and wait till I get there. And then the next thing he did was call for backup. You don't call for backup for somebody who's just a visitor at the county jail. Which brings me to the fact that, I mean, he should never have been out in the first place. He had 50 pounds of pot that was valued at $100,000.
What's that got to do with the issue before us today?
Right. Because Your Honor, they're trying to say at this point, Wabunsee County, that, hey, this doesn't matter, that he was just a regular visitor, and that's the point. He was not just a regular visitor. He was a drug-running, undocumented alien who had who Wabunsee County thought should be locked up.
Before we proceed, counsel,
Yes.
I'd be interested in your answer to the question I posed to opposing counsel, and that is, what is our standard to determine, as you put it, whether this individual was in custody? You've told us about a number of factors, but can you lead us to a conclusion on a particular test?
Yes, I think the clear test was articulated by the court in State v. Lewis, which is whether or not he was free to leave.
Based on his objective understanding of the facts?
The case law doesn't specifically state, I believe, whether it was his objective test, but I think a reasonable person would have assumed that they were not free to leave. When they handcuffed his friends and his sister, those people stated that they believed they were under arrest. People, when they're handcuffed, don't generally think they're free to leave.
If it is an objective test on what is known to him, then what relevance does it have that the jailer perhaps felt insecure, so she called for her boss, and her boss then called for backup?
Well, it goes to their intention of placing him in a position where he didn't think he was free to leave. They put him somewhere that they considered secure.
But how would the individual in this case know what their thoughts were or what their actions were?
Well, he couldn't completely know that, but when he's escorted into the jail behind the locked door and then put in the room that he can't get out of, I mean, he wasn't stupid. Captain Lamb comes in and says, hey, what about that ICE detainer? And he's like, I don't know. And he realizes, he sees the writing on the wall, what's going to happen when they figure out that the ICE detainer is still on.
So as I understand what you're telling us, we should look at this from his viewpoint on what was known to him, and then whether he was justified in feeling that he was in custody?
I don't think you just look at it from his perspective. I think his perspective plays an important role in whether or not he was free to leave. But I think you have to look at the surrounding circumstances of what a reasonable person would see looking at the same situation, whether he reasonably believed he was free to leave. If he was just there and there was no indicia of custody, he maybe was left in the room with the door open, that would be a different scenario. But based on his interpretation, and then I think what a reasonable person would see as whether or not they had the freedom to walk out the door that day.
So there are two prongs, a subjective and objective? Is it like self-defense, or is it like Miranda, where we look at a reasonable person who would have felt free to go?
Sure. I don't think that the court has actually set up that standard at this point.
What's your view on it?
My view is that it's a two-part standard, whether the person believed they were free to leave and whether reasonably looking at the situation, that person in fact was free to leave. And in this instance, all those factors combined, I don't think Mr. Contreras thought he was free to leave, or perhaps he would have, and when he did try to leave, he couldn't get out the door, so he broke the window. And then looking at the circumstances surrounding him being placed in that room, the jailer testified that she felt that was more secure. She was alone there by herself. She was waiting for her supervisor who had called for backup. All those factors together show that not only did Mr. Contreras believe he was not free to leave, they were keeping him there in a secure facility as well.
And both those tests need to be met in order for him to be found in custody.
Yes, I would say that would be an appropriate test. I think it's also important to note that after he jumped out the window, Captain Lamb came racing through two different locked doors to get to the fingerprint room, where he looked out and saw Contreras laying on the ground. He then runs down the stairs with his weapon drawn, pointing it at Contreras as he lay there. Contreras had tried to get up and run away, but his hips were broken and he couldn't move. He then handcuffed Contreras, who both he and Jailer O'Connor testified they could see his heart beating in his chest, and he couldn't move. So they handcuffed him anyway. They handcuffed his friends. They had their service weapon. He had his service weapon drawn. Again, when the courts looked at these types of situations, specifically in the Susan B. Allen, in the Dodge City case, they said that looking at these situations, could we really believe that this person, they would have just let him run off into the sunset had he not broken his hips? And I think that the fact that they handcuffed him as he lay bleeding on the ground and had their service weapons drawn and handcuffed his friends, while yes, they were concerned for their safety, that goes to show that they would not have just let him leave the situation.
And you're taking that tact because he committed the criminal damage to property before he hit the ground? And
No.
so he would have been apprehended? I mean, I don't understand why what happened after the injury is germane to our inquiry as to whether he was in custody or a prisoner or whatever at the time of injury.
That's true, but I think, again, it goes to, the criminal damage was not testified to, and it was not something that was a factual conclusion based in the district court. It was mentioned by the Court of Appeals. But I don't think that was central to the holding. I think what the court was saying was, like in these other cases, that he wouldn't have just been allowed to leave, which again goes back to, was he free to leave to begin with?
I understand the argument when he's in the room. What I don't understand your argument about being handcuffed on the ground after the injury occurred. Why that has any bearing on what we have to decide?
Because it goes to show that this wasn't just, again, a visitor that for some unknown reason jumped out. They were so concerned about this person, and they were concerned about the security and the safety of this individual, that they handcuffed him even after the injury when he was laying bleeding on the ground. Then when they laid left in LifeStar, they sent him off to the University of Kansas Hospital. Captain Lamb was on the phone faxing the ICE detainer saying, hey, we've got this bad guy coming to you. You need to be on the lookout for him. The Kansas University Police Department, which is not security, it's an actual police unit, met the helicopter on the top of the building. So again, this was not just a random visitor. He was somebody that was known to be a gun-toting, drug-running, undocumented alien with a pilot's license. They were concerned that he should not be out free and that he had possibly escaped. And we're not arguing that this creates any sort of long-term liability. Contreras can't come back now and say, hey, I need a hip replacement for what you did. What we're talking about is the acute injuries that occurred during his custodial period. Once he's released, he's done. We're not saying he gets free medical care for life. We're not out there to establish a sort of workers' compensation program for prisoners. But we're saying when you bring someone into the jail and you put them in a room that they can't get out of, and then they're injured, that's custody, and at that point, the county needs to take responsibility for the person that they have in custody. And unless there are other questions, I will conclude.
Do you have any further questions of counsel?
Thank you.
Before you sit down, I am kind of curious.
Sure.
If he's in custody in this room and then he leaves the room, is he still in custody?
Was he free to leave?
Well, he apparently left.
I'm sorry,
You indicated he was in a room,
right,
and all the indicators, according to you, are that he was not free to leave, therefore he was in custody. He then left.
Mm-hmm.
Is he then out of custody, and therefore there is no obligation for the county to pay his medical bills?
Once he left the hospital.
Once he left the room that you say he was in custody in, has he not left the custody of law enforcement?
At that point, but the injuries occurred while he was in custody.
While he was
again,
leaving custody.
Well,
I mean, the
right,
analog
leaving
is a
custody.
prisoner who escapes and then gets shot while he's out escaped.
Right, and the Mount Carmel court said, he was still in custody. They were going to pick him up. Just because he was in the process of fleeing doesn't change the fact that he was a person in custody when he started the actions that led to his injury.
Very well, thank you. Any further questions of counsel?
Well, just to clarify, you're saying that an escapee is still in custody for purposes of medical responsibilities? Is that what you're saying?
If they're injured during the escape or immediately thereafter, then yes. Under this court's line of cases, starting with Mount Carmel, I believe that's the holding. Thank you.
Thank you.
Just on those first two factors, I've been in custody. Any attorney who's visited a client in a local county jail would find themselves in much the same situation, visiting law enforcement who are visiting another facility would find themselves in a very similar situation. They're brought behind some secured door, maybe asked to take a seat while things are being arranged.
The big
But you're
difference
afraid
is
of it.
that when I've been in interviewing and I knocked on the door, they let me out.
Well,
If you're being held on an ICE detainer, that they can knock on the door and they're not going to let them out.
but in this situation, nobody heard him knock on the door. Jailer O'Connor wasn't even that part of the building. There was no way she could have heard it. And I would point out, even though we mentioned that, and who knows what the officer was thinking, that ICE detainer is no basis to hold him. Under law, that is not a basis to hold him. It is not a warrant. Maybe the officer didn't understand that, I don't know, but if you look at the actual cases, and it's been discussed in the lower court briefs, it's not a basis to detain
But
in this
it-
situation.
Isn't the inquiry whether Mr. Contreras would know that? If Mr. Contreras says there's an ICE detainer, he has to know that that's not sufficient to make him stay in that room or stay in that jail.
Well, I would think he would draw that conclusion. He went to Shawnee County, he bonded out of Shawnee County. He's a free man when he comes to Wabunsee County. I would point out...
Wasn't he told to go in this room, wait here until I, according to Captain Lamb, check out this detainer?
Yeah,
Wasn't he
right.
told to do that? I mean,
Have a seat is the direct quote that Judge Elder has in there.
and wait until
I check it out. My doctor does that to me. I want to not miss one particular point that we haven't addressed here that's extremely important based on the finding of the Court of Appeals that he was in custody. So when does it end? In this situation, unlike all the other cases, you talked about the Gray County case with the burglary shootout. The guy's in there for 3 weeks. But the sheriff took him there to the facility, monitored him on a regular basis, and showed up there when he walked out with a filed complaint and took him off. Here, what happens? They never talk to Wabunsee County again at KU Med. Who do they call on the day he's going to be released? First, they call ICE, because that's who's listed on their Form 571. Then they call Shawnee County. Couldn't get a hold of anybody there that day, and he leaves. So why is it that he's in Wabunsee County's custody that whole time, unlike the other cases? This is critical because we're talking about money here. I mean, that's what this comes down to. So if he's there for 2 days on our bill, okay, I guess we'll have to look at that. But does that mean we pay the full freight? How do you decide when someone's out of custody? We know that he became ambulatory on no later than the 16th of April. He'll leave on the 27th. He's not restrained there. He's not guarded there. He can walk out of KU Med under his own power on that date. They don't call us about that. Why is he in Wabunsee County's custody from the 5th until the 27th when he walks out of that facility there? Why isn't he in the custody of the University of Kansas Police Department? They're a full police department. What about Wyandotte County? He's sitting there in Wyandotte County, Kansas, presumably because of this ICE detainer. There's no warrant for him from Wabunsee County. There's no instructions that he's on a police hold. He's never charged with a crime out of Wabunsee County. So when you look at that, what's the answer to that particular question? I think there should be an answer. If this court chooses to affirm the Court of Appeals, which is your right, then what's the answer to the question of when did he leave custody compared to the other cases, particularly given who was interested in him and the forms that KU had only listing ICE. Lastly, before I leave with just my last moment here, as I mentioned, the Court of Appeals decided a case on the 13th of September. Petition for review has been filed. It involves University of Kansas Hospital Authority, Wyandotte County, and Highway Patrol. And it goes to that newer statute. But Wesley's important here because of what happened before. Wesley deals with felony misdemeanor. Who's responsible? It didn't quite address that. My time is at an end. Thank you very much.
Before you sit down, counsel, I had asked you a question during your initial presentation about what standard you believe we should apply, and according to my notes, you told us, well, it could be Lewis, it could be Miranda, it could be statutory, it could be Warrior. So before you sit down, could you tell me what you believe the standard should be applied to determine whether this individual was in custody?
Well, if I was the kingmaker, I would say, look at the statute, 22029, because it defines custody there, but it also defines detention. Are we going to obliterate detention in the expansion of the use of custody? Because detention has a little bit of meaning. I take it when I read detention by the statute that they're talking about a Terry stop. Custody is something different. So it would seem the clearest, the easiest to use that word custody. But I know I didn't give you a direct answer because the courts have not chosen necessarily to use that. They didn't in the Butler County case by clear acknowledgement. They didn't, although the facts there are substantially different. The officers brought him to the Susan B. Anthony Hospital. They brought him there, but they brought him to the jail. From the hotel to the jail, the officers took him. From the jail to the hospital, the officers took him. They said he was in protective custody on the sheet when they brought him in. And lastly, you had the alcohol treatment code as a form of custody. That's substantially different factually than what we have here.
All right, thank you. Do we have any further questions of counsel?